Okay, thank you. Good afternoon, everyone. I'm delighted to be here in person at this 38th Investment Treaty Forum Public Conference on complex arbitration proceedings in ISDS. I have the great pleasure of chairing this second panel session on parallel and multi-party proceedings. Parallel and multi-party proceedings are on the rise. Starting with Abaclat in Argentina, increasingly, tribunals are being asked to decide claims brought by multiple unrelated investors with distinct investments in a single arbitration. And we will spend some time today considering the procedural implications of multi-party proceedings and mass claims. Turning to parallel proceedings, a distinction is to be made between overlapping and complementary proceedings. And we've heard earlier today from Alex Slade on questions of res judicata, and as he neatly put it, the tangled web of causes of actions and rights. Increasingly, commentators are examining the problem of overlapping international dispute proceedings and the possibility they raise of conflicting factual and legal determinations, inconsistent remedies, and inefficiencies. Whether it's in the context of parallel contractual arbitration claims, human rights proceedings, or international trade proceedings, increasingly, we are fighting on multiple fronts, in different venues and jurisdictions. And with that comes added complexity and cost, and the need to consider carefully and anticipate both procedural and strategic issues. I'm delighted to be joined this afternoon, by three distinguished panelists, each of whom will present to you today on a topic of particular interest to them, before we open the floor up to questions from the audience. To my right is Matthew Happold. Matthew is a professor of public international law at the University of Luxembourg and a barrister at 3 Hare Court, London. He also sits as a recorder on the Northeastern Circuit, authorized to sit on civil and criminal cases. In 2022, he was appointed to the European Commission's list of candidates suitable for appointment as an arbitrator. Sorry, a second. Yeah, that's it. We're done with you. Matthew was a member of the Commission Consultative des Droits de l'Homme, Luxembourg's national human rights institution, for over 8 years. Matthew's published widely across the international law spectrum. Publications include EU External Action in International Economic Law, Recent Trends and Developments, and Economic Sanctions and International Law, as well as articles in the ICSID Review, the International and Comparative Law Quarterly, and the Journal of World Investment and Trade. Matthew will present today on ISDS and international human rights proceedings, exploring both procedural and substantive issues and obligations, and the use of international human rights proceedings as both a sword and a shield. Matthew will also consider international human rights mechanisms as conflicting with, complementing, or providing an alternative to ISDS. Next, we have Jeff Sullivan. Jeff is a US and English qualified King's Counsel and partner in the London office of Gibson, Dunn and Crutcher, where he also serves as co-chair of the firm's IA practice group. He represents clients in both commercial and investment treaty arbitrations, as well as aspects of public international law. He also regularly sits as arbitrator. He has acted as counsel in more than 30 investment treaty arbitrations, acting on both the claimant and respondent side. He's advised states in Europe, Central Asia, and the Middle East on the negotiation and drafting of trade and investment treaties. Jeff is a member of the ICC UK Arbitration and ADR Nominations Committee, a member of the ECT Secretariat's Legal Advisory Task Force, an executive board member of the European Federation for Investment Law and Arbitration, and an executive committee member of the Foundation for International Arbitration Advocacy. Jeff will present today on multi-party proceedings and mass claims. Jeff will consider when mass claims arise, the arguments for and against them in ISDS, and highlight the key issues arising in mass claims and what trends we might expect in the future. Next, we have Dr. Aniruddha Rajput. Aniruddha is a member of the UN International Law Commission. He served as the chairperson of the drafting committee on the International Law Commission at its 69th session in 2017. Aniruddha advises and appears on behalf of states and private entities before international courts and tribunals, and currently practices as a consultant, public international law and international arbitration at Withers here in London. His areas of research and writing include general international law, law of the sea, boundary disputes, international trade, and investment law. He has published and lectured in these areas. Aniruddha will present today on the interplay between ISDS and international trade proceedings. He will discuss their common roots and consider instances where similar remedies resulted from ISDS and international trade proceedings. He will explore the differences in substantive law and available remedies and the interplay between parallel sets of proceedings. I think you'll all agree that I am surrounded by very distinguished panelists, and so without further ado, I'm going to hand the floor over to Matthew.
Thank you very much, Louise. How long do I have?
You have a strict 15-minute time limit.
Strict 15, not an extra 10, 15, or even 20
No,
seconds.
otherwise a hungry mob.
All right, well,
you know.
I'll probably be a member of that hungry mob. Thank you very much. I've been asked to talk about the relationship between state dispute settlement and international human rights proceedings. So not talking about proceedings before national courts, but before different international procedures, international arbitration on the one hand, whether under the auspices of ICSID or other institutional rules or ad hoc, and on the other before some other international court or adjudicatory body. And that's that's important, I think. But there are a variety of human rights adjudicatory bodies, and I use the term advisory because there are various courts which have been given, or in some cases have assumed, an individual course or tribunals which have been given or assumed a human rights jurisdiction. We have the European Court of Human Rights, we have the Inter-American Commission and Court of Human Rights, the African Commission, Court of Human Rights, the Court of Justice, my particular favorite, Court of Justice of the Economic Community of West African States, the East African Court of Justice, and so on. But there are also various other bodies which have an adjudicatory function, but which can't issue binding decisions. The Human Rights Committee, for example, established under the International Covenant on Civil and Political Rights, the UN Working Group on Arbitrary Detention, which was established by, well, it's under the auspices now of the UN Human Rights Council, the European Committee on Economic Rights under the European Social Charter, which has a collective complaints mechanism, and so on and forth. Now, it's sometimes said that they produce binding decisions, but they only do so insofar as they refer to legal binding provisions, and they're a monitoring body established by the relevant treaty. I'm not quite sure that means they're binding. I don't think it does. So I'm largely going to restrict myself to international human rights courts. I think it's important in the first place to recall, of course, that litigation before all of these bodies is different from investor-state arbitration. And it's established because the jurisdiction of all of these bodies is established on a different premise. There's no nationality requirement, unlike ISDS. International human rights law is explicitly not based on nationality. You simply have to be a person within the jurisdiction of a state when the alleged violation took place, and that violation has to be attributable to the state. And there are two other particular differences. The first is that unlike investor-state arbitration, and we heard about this earlier this morning, it's almost invariably a requirement in order to take your case to an international human rights court that you've exhausted domestic remedies at the national level. So you have sought a remedy at the national level. You have taken your claim to the national courts. There are some exceptions to that, but they're fairly exceptional. You don't need to do so to go to the Court of Justice of ECOWAS, is really the main exception. The second thing is, of course, that in most cases, only individuals and not corporations, natural, not legal persons, can bring claims before international human rights courts. there's one minor exception, which is the ECOWAS Court, which is another reason why it's one of my favorites. And the other is the European Court of Human Rights. There, if you look, it explicitly states that claims could be brought by individuals and what it rather quaintly now refers to as non-governmental organizations, by which it means corporations. If you're a corporation, you can bring a claim before the European Court of Human Rights. You don't even need to be of the nationality of any of the contracting states. There's a case called Iranian Shipping Corporation, where an Iranian corporation brought a claim against Turkey. Claim was admissible. There was no problem for that company to bring the case. So immediately you can see why you might want to use investor-state arbitration rather than go to an international human rights court. For a start, if you're a corporation, you might not be able to. Europe's the major. And secondly, do you really want to have to go through the national courts? So there are actually surprisingly few examples of situations where there is a potential conflict. I will talk about one. So, what is the situation if there are parallel proceedings? What is the situation? Well, from the investor-state dispute settlement provision perspective, and now I'm already getting worried that I'm using up my time. What can you look at? Well, Alexander Slave's already told us all about res judicata, and I won't say very more. If you take the sort of triple identity test, and attempts have been made to rely on fork in the road provisions in treaties. So if you look at Article 20, I think it's Article 26(3) of the Energy Charter Treaty, which says if you submit disputes to the local courts or tribunals or to any applicable previously agreed dispute settlement procedure, then you can't bring arbitration proceedings. And in reality, I think those res judicata and fork in the road provisions are somewhat linked. And indeed, we saw that in the UCOS case, which I'll come to. So if we look at triple identity, the objects of the two claims must be the same. In most cases, that may well be satisfied. Remedies may differ, but usually it's what's being sought is compensation. We're talking about financial interest. But are the grounds or the cause of the claims the same? We've seen this already. Inferior actions brought under different instruments constitute different causes. In some cases, that may be artificial, and there's certainly jurisprudence that suggests that. There's jurisprudence outside this area, such as the Southern Bluefin Tuna case, which I won't go into, but of course, famously, CME told us that under even cases concerning the same acts of expropriation are separate causes when they're brought by different persons under different bilateral investment treaties. And in most cases, of course, claims under human rights treaties will be different, at least in form. Claims tend to be for breach of the right to a fair trial and the right to property. Plainly, they're related to fair and equitable treatment and the restrictions on expropriation in investment agreements, but they're perhaps not entirely the same. So this came up particularly in the UCOS case. There you have proceedings both before an arbitral tribunal and before the European Court of Human Rights. But the difference is that before the European Court of Human Rights, the claim is made by the Russian company, which is by that time, interestingly enough, in liquidation, but by the end, and in international arbitration, it's brought by the majority shareholders to the Russian company, which, if I remember, are organized under the laws of the Isle of Man and I think Cyprus. And there, Russia did argue that it was a matter that was being dealt with by the European Court of Human Rights, did argue fork of the road under the Energy Charter Treaty, to which UCOS replied that there's a failure to meet the triple identity test because the claimant was not a party to any of the proceedings for the European Court of Human Rights on the one hand, and on the other that none of them concern an alleged breach of Part 3 of the ECT. And the tribunal agreed with that. They said there's ample authority for the application of a triple identity test in the context of a fork of the road provision. That was at the that was in the interim award on jurisdiction and admissibility, which was back in 2009. The issues then pursued in the merits proceedings, and the tribunal says we're not going to reopen the matter in its final award in 2014. So we end up with, in fact, an award in UCOS, what's it, 50 billion euros, and we end up with a judgment of the European Court of Human Rights, which it takes, I think, till 2008. No, it is also till 2014, but it's a couple of months later, I think September 2014, which awards UCOS 1.3 billion euros, which I wouldn't say no to, but is considerably less. Now, interestingly enough, the European Court of Human Rights doesn't seem to be particularly worried about the fact there are parallel proceedings ongoing. In reality, you probably want to look at Article 35(2)(b) of the European Convention on Human Rights, which says the court shall not deal with any application if it's substantial, if it's already been submitted to another procedure of international investigation or settlement and contains no relevant new information. Now, it seems to me that's apt to cover investor state arbitration, but obviously different parties here. So I'll just, because I realize I'm already running out of time, but loads to say. If we move straight to the UCOS case before the European Court of Human Rights, the judgment, actually it's only 2 weeks after it. I think the final award in the UCOS arbitration is, I think, the 14th of July 2014. The judgment on just satisfaction of the European Court of Human Rights is on the 31st of July 2014. And it's interesting for a number of reasons, which I'll mention. The first is it says there are exceptional circumstances which allows the shareholders of the company to seek essentially the company to enforce its rights under the convention in relation to events prior to its liquidation, and to seek successfully compensation. And what the court said was that, notwithstanding UCOS's liquidation, indeed because of it, the shareholders were entitled to compensation in their own right for the pecuniary harm the company had suffered. And the court required Russia to arrange for payments of the funds to shareholders in proportion to their participation in the company's nominal stock at the date of dissolution. Now, you might say, well, what about double recovery? If you go back to the UCOS final award, it's not an issue there because the European Court, well, it is an issue, but the European Court of Human Rights hasn't yet ruled how much compensation it's going to award. And they just deal with it by acknowledging that the claimants have already said that should only any pecuniary damages be awarded to UCOS in the European Court of Human Rights proceedings, and should the claimants receive any payments, which is the important bit, such payments will be deducted from the amount claimed in the arbitration. What happens in the case before the European Court of Human Rights? The court says, well, we know there are already awards by them. There are awards with regard to the minority shareholders. We know there's going to be award as regards to the majority shareholders. And the court does not find it necessary at this stage to take the information into account in the context of the present judgment, which is very helpful. So that's really the only, I think they both the tribunal and the European Court of Human Rights saw the issue of double recovery as really a sort of case management issue. I don't think there's much more to say. Now, I notice I've got no time left now.
I think we probably have 2 minutes.
I've got 2 minutes left. I just wanted to deal with one more issue because Louise said I was going to deal with lots of interesting things, but perhaps you can ask me, which is whether you can use international and human rights proceedings as a shield rather than a sword. I'm not going to deal with that. But I will deal with the final issue, which is, are international human rights mechanisms, do they conflict with, do they complement, or are they an alternative to investor state dispute settlement? And the answer is possibly they conflict at times. I haven't had time to deal with it. If they do, I think it's at the level of conflicts between the obligations under different treaties, which I think are often, in many cases, false conflicts. Because it's possible to comply with both at the same time. That's particularly the case, I think, with questions concerning land. It's a question of treaty interpretation, it's a question of applicable law. Are they complementary? Well, possibly. UCOS seems to suggest that, but obviously subject to double recovery issues. Are they all an alternative? No, they're not an alternative. It's sometimes said, if you look, international human rights courts are a forum that you might want to use if you can't access investor state dispute settlement. It's sometimes said that some issues might be dealt with by human rights courts that the investment tribunals can't deal with. That's obviously true, but there's a line of jurisprudence, of course, that suggests that argues that investment tribunals can award moral damages, and there are a number of cases where they have done so for matters, relating for the treatment of individuals relating to how the investment has been treated. Going back to Desert Line, looking at Fon and Zimbabwe, which I think is an awful award for a number of reasons, but I can't go into that now. But so if you can't go, I think the moral of the story is I could say more about how difficult it is to win a case before the European Court of Human Rights. I speak from bitter experience, but I'm not going to. I'll end there. Thank you.
Thank you very much, Matthew. I'm sure there'll be lots of questions at the end.
I hope so.
I'm going to hand over to you now, Jeff. Jeff is going to talk to us about multi-party proceedings and mass claims.
Thanks, Louise, and thanks, Yarick, as well for the invitation. Marcin mentioned in the last panel that he's an alumnus of BICO. I am as well. He was. I'm guessing you. I was about to say Marcin's title was scholar in residence. I was an intern, a slightly less glamorous title, and I think he was 14 years ago. It was a bit beyond that, but I won't give the date. But thank you for it's always nice to be back. So multi-party proceedings and mass claims, what are we talking about? I'll start with describing what I'm not going to discuss. Multi-party claims by affiliated companies, parent subsidiary, brought, part of the same corporate group, brought as a single proceeding. That's not controversial. That's not what we're here to talk about today. Those often involve the same corporate group, the same investment. It's effectively the same claim by affiliated companies. Those claims do cause problems if they're brought in separate proceedings. That's the parallel proceedings issue where CME, Lauer, where you have the risk for inconsistent decisions. I'll come back to that when we talk about some of the pros and cons of mass claims. But those claims are not controversial. What I'll focus on today are claims that are brought by unaffiliated claimants based on separate but similar investments in a single arbitral proceeding. And we've seen a number of those claims over the last 10 years, an increase in the number of those claims. You've got the bondholder claims against Argentina, that's Habitat, Alemany, and Ambiente. You have renewable investors against Spain, the PV investors claim, and the Matthias Crook group of claimants. So those are just two groups. There are others as well. And in all of those cases that I've just mentioned, there's been objections raised by the respondent state as to the mass claim nature of those claims. So there's objections to jurisdiction, there's objections to the admissibility, and then there are due process concerns that are raised by the respondent states as well. Those objections have largely failed. There are a few nuances there, which I'll come on to. But we also have cases, I should mention, where you have a clear mass claim aspect where no objection was raised by the state. So the Anderson versus Costa Rica case, there were 137 claimants brought claims against Costa Rica. The state raised a host of jurisdictional objections, but they didn't object to the mass claim nature of the dispute. And I think that's important to mention when we come into the end to talk about this current state of affairs and the way forward. I'll touch on that again. The terminology on this topic can be a bit confusing. You see in the cases different terminology used by tribunals: mass claims, collective claims, aggregated claims. I don't think it makes any difference. There's no normative content attached to the labels. I mean, one question is, when does a multi-party claim become a mass claim? Is it 5 claimants, 10, 50, 100? Arbitral had 60,000 bondholders. It doesn't really matter. I think when you come on to look at how the cases are decided, what's more important is the similarity between the claims and the investments and the claimants themselves, not the number of claims. Greater number can present greater challenges, but again, we'll talk a bit about case management in a minute. So that's what we're here to talk about. I want to start by mentioning some of the pros and cons of mass claims or collective claims in the ISDS world. As always, there are arguments for and against, and obviously there's lots of debates in domestic law. Here in the UK, there was a big review of the collective action procedures in the English courts about 10 years ago. It's a growing area here, and some of the same issues that you saw raised as concerns in the domestic context get raised in the ISDS context as well. So arguments in favor of mass claims: consistency and predictability. So separate proceedings can result in divergent interpretation of the treaty provisions. You can have very similar claims, very similar, both in terms of the investment, but also in terms of the provisions of the treaties that are being relied upon, being interpreted in very different ways. So the risk of inconsistencies is there. Judicial economy is the second big point. Again, there's a host of arguments in favor of mass claims in terms of judicial economy. Separate proceedings, without doubt, increase costs for both the state and for the claimants. Group claims can be determined, at least in theory, with greater efficiency. And again, this cost saving works for both sides. So the state benefits by resolving disputes more efficiently, more economically. They face a single proceeding as opposed to a multiplicity of proceedings. And obviously for the claimants, there's cost saving as well, as they share costs in bringing the claim. So judicial economy is the second point. The third is access to justice. Collective claims provide an avenue for claims that might not otherwise be brought because of the cost. So this benefits individuals, small and medium enterprises as well, who may not otherwise be able to enforce their rights effectively because of the cost and length of investment treaty proceedings. Access to justice promotes the rule of law, so it can be viewed as another way of keeping the states in check in terms of upholding justice. The theory again behind ISDS, if we go back to the sort of very beginnings of this, is to prevent a state from abusing its rights over foreign investors, and again, access to justice is an important aspect of that. And it's also, as I said, one of the arguments for collective claims in the domestic context. Those are the arguments for mass claims. What are the arguments against mass claims? First and foremost, due process concerns. States think that there is a risk that they may not be able to adequately defend against mass claims. Will the state be able to fully probe and defend the claims that are being brought in circumstances where there are many hundreds, sometimes many thousands of individual claimants? Will there be disclosure available for each individual claimant? Will they be able to cross-examine witnesses from each individual claimant? How will they assess loss across a multiplicity of claimants? So all of these points go to the state's right of defense and due process concerns. That's the first argument against mass claims. Second, and relatedly really, there's a lack of guidance for tribunals as to how to manage these claims. So you have no institutional frameworks, at least currently, that are set up to deal with mass claims. The ICSID rules don't address this. The UNCITRAL rules don't address this. There are no IBA guidelines, believe it or not, on mass claims. So the tribunals are left to themselves. And suffice it to say, those of us in this room usually come from a history of working on arbitration cases involving individual claimants. Arbitrators have had very little experience doing mass claims, so they have to come up with solutions to these due process problems without much guidance. They can always, of course, look to have domestic courts deal with these issues, but it will be unfamiliar territory. That's another concern. On the, I guess, more cynical side, states have argued that the ability to bring collective claims means they're likely to face more claims. I'd say that that's cynical because I don't think preventing access to justice is necessarily a good thing. And in fact, it's the same argument that the business community uses in the domestic context to oppose class actions. Here, the tables are turned. So you have the business community wanting to use this process in the domestic context. Of course, they're against class actions and collective claims. So I don't think that's a particularly good argument against mass claims. What's probably the more relevant concern is the potential for abuse by third parties who have a financial stake in these claims. So the sort of ambulance chaser concern. And obviously with the rise of third-party funding, there's been many concerns raised in this context. That, I think, is a legitimate concern. I don't think preventing mass claims is the way to deal with that. I think that's best addressed through summary dismissal procedures and things like that, Article 42 of the ICSID Convention. Those are the arguments for and against. What's the current state of affairs? There have been quite a few of these cases I've mentioned. The 3 Argentinian bondholder cases, all of which begin with A for reasons that Sam now knows and is embarrassed that he forgot. Alphabetical listing of claimants, A comes first. 60,000 bondholders in Abaclat, 90 bondholders in Ambiente, 74 in the Alemani case. The Adamopoulos versus Cyprus case, it's a tough one to say, 960 bondholders. I had it before and then Alex heard me say it perfectly. Now I've stumbled. 960 bondholders in that case. All bondholder cases. So again, in terms of similarity, they really are quite similar. The Spanish renewables cases, you have 2. The PV Investors case, 88 claimants, and then the Matthias Kruk versus Spain was 116 claimants originally. So we've got some case law, and all of those cases objections were raised. And I now want to just very briefly touch on what are the key issues that the tribunals are looking at and determining in those cases. The first is consent. Is a secondary or special consent required on behalf of the state in order to bring a mass claim or collective claim? Sam mentioned in his keynote that the treaties often contain language which could be interpreted, perhaps if you're faithful to the Vienna Convention, to suggest there's an answer to this. The tribunals don't seem to really engage in a detailed textual analysis. All have some textual analysis, but I don't think that textual analysis seems to be ruling the day. I'll give you an example. Abaclat found that the ICSID Convention's reference to a requirement for the dispute between a contracting state and a national in the singular of another contracting state was not determinative of the issue. That wasn't a prohibition on mass claims, the fact that national is referred to in the singular. Erhas versus Turkmenistan, this is a case with, I think, 140 claimants. It found that references in the Turkmenistan BIT to disputes in the plural did not mean that mass claims were permitted. So the sort of very opposite conclusion reached by Abaclat. Now, not to be too flippant about this, obviously you have to do that textual analysis in the context, object and purpose in the context of the treaty. And I think ultimately the way the tribunals come out on this is to say the treaties really don't tell you much. They're effectively silent on this. And just the fact that you see singular reference to investor or plural reference to disputes isn't actually determinative of the issue, because that's not what the treaty drafters had in mind when they drafted those provisions. So that doesn't rule the day. So how do these decisions get made? Well, effectively, you have two schools of thought. PV investors and Abaclat effectively said, so long as the tribunal determines it has individual jurisdiction with respect to each claim and claimant, the fact that they're all brought together doesn't make any difference. So you do an individual analysis, and if all individuals pass the test, then that's all that's needed. So you see that in PV investors and Abaclat. Alemany took a slightly different approach. They ultimately found there was no issue, but effectively they said so long as they're sufficiently similar, which is really the next issue, and there's a single dispute before the tribunal, that satisfies the jurisdictional requirements. So consent jurisdiction is the first issue. Alemany and the Matthias Crook, the Spain case, focused on this issue of single dispute, really more as a question of admissibility than jurisdiction. And ultimately what they're looking at is whether these cases or the claimants and the claims themselves are homogeneous. Are they similar enough, or is there some reason why this multiplicity of claimants jurisdiction should not be exercised because they're too different effectively? So put another way, the question is whether, even if the tribunal has jurisdiction over each and every individual claim considered in isolation, is it appropriate for the tribunal to treat all the claims together as part of the single dispute? It's an admissibility issue. So the key question there is one of homogeneity of the claims. So looking at the language that the tribunals use, Abaclat, they found that the claims were, quote, essential in all respects, or identical in all essential respects, excuse me. Same treaty at issue, same measures being challenged, same type of investment, government bonds. So sufficiently similar not to present an admissibility issue. The Cyprus case, again, the only difference between the claimants there is that some were under one treaty, some were under a different BIT, but the tribunal found that the language of those two treaties was essentially the same, so that didn't present any issue. So they found that there was, quote, substantial unity between the claimants, a slightly different formulation. And then PV investors found that a sufficient connection exists. That was the language they used. Moving on, so that's the first issue, is consent and dispute. Then due process is the second issue. Here, it's not jurisdiction, but it's the question of how you manage this. The tribunals in each of these cases have used specific, procedures that they've put in place to address the multiplicity of claimants. Abaclat, for example, they delegated the question of determining whether each individual claimant met the jurisdictional requirements to a third-party expert or secretary. Again, adopting from domestic court procedures there. PV investors, they bifurcated questions of liability and quantum. Same in the Cyprus case, on the theory that liability will be the same for all, but quantum might be different. But that's really the sort of key issues that they've found that they've needed to address. What they don't seem to be concerned about are the liability determination. So quantum and jurisdiction raise some issues, but on liability, they haven't adopted any specific procedures, primarily because they've resolved that first by determining that the claims were essentially homogeneous and didn't require anything different. So that's a quick overview. I think I've got two minutes left. Let me just give you this looking forward aspect of this. So we've had a lot of discussion over the last 5 years on reform of the ISDS system. The UNCITRAL Working Group is obviously at the forefront of that. Interestingly, there's been almost no discussion at all about mass claims. no real concerns raised in that process. In fact, one of the primary guiding principles of the UNCITRAL Working Group is looking at reforms that will promote efficiency, and obviously mass claims arguably do promote efficiency. So very, very little discussion on reform in the context of mass claims. ECT modernization process is underway, and the document's been leaked, as Federico mentioned. We've had 2 mass claims under the ECT against Spain. That issue wasn't taken up at all in the ECT modernization process either. So it doesn't seem, although there's some criticisms if you read the commentary about Abaclat and Ambiente, and some concerns raised about due process, what you don't see is any movement by states to try to change or reform the system to somehow prevent mass claims from going forward. So for now, it seems at least it's something that's here to stay. One question is, will the various arbitral institutions, ICSID, the SEC, will they adopt any reforms to the rules to help tribunals manage this? That might be welcome from the tribunal's perspective. I'm not personally suggesting that that's a good idea. I think overly prescriptive rules sometimes are more of a hindrance than anything. I like tribunals having their own flexibility, but we could start to see frameworks being proposed by the institutions themselves, or by the IBA or some other group to help manage the situation. But for now, I think it's a trend that's here to stay. In fact, we'll probably see an increase in the number of mass claims going forward. Thanks.
Thank you. And last but not least, we're going to hear from Anna Ruda on ISDS and international trade proceedings.
Thank you, Louis. I must say I was very pleased when at the beginning of this session there was this well-known sound of the microphone, because it just reminded us that we are back to normal times, and it's really pleasing to see live humans in front of you rather than an emotionless screen. Although I see that some of us have to look at the screen and look at us, even with our emotions as emotionless for those who are on the Zoom. But I'm glad that we have had a convergence. What I intend to look at is the conversion in the context of ISDS and international trade law proceedings. Now, this convergence or divergence really sits at the cross-section of law and strategy. On the aspect of law, there is certainly issues about how one area of law influences the other. What we do see in the arbitral practice, in the practice of investment tribunals, they do very often rely on jurisprudence of WTO panels and appellate bodies. But we don't see the other way around happening. The panels in the appellate body are happy not to refer to any of the works of the investment tribunals. But as Yarik pointed out towards the beginning of this panel, or this whole session, or this event today, that the goal is not to look at the conceptual influence of one regime on the other, but rather to look at the practical functioning of disputes in what one can call complex disputes. I think a good starting point to look at this interplay of law and strategy is to look at the examples of, firstly, of course, the recent, or rather not so recent example of the Australian plain packaging case. But the one before that, which was played out far more extensively and intensively, which originated in a dispute between Mexico and the United States, and the investors got caught in the crossfire, which was known as the Mexico corn syrup or the sweetener case. I think that is a very good example to begin with, because it gives a much deeper flavor of how trade and investment tend to overlap and interact. Now, in that case, what was in challenge was basically the same measure by the Mexican government. The Mexican government introduced a tax. The tax said that you can only, if you use the domestically produced, or not just domestically produced, if you use cane sugar to make your syrups, then you are exempted from all taxes. But if you use anything else, then you have to pay 20% tax. And you don't just pay 20% tax, you also pay 20% tax on handling and services in relation to this product. Now, what looked to be a simple taxing measure was actually aimed at protecting their own domestic industry, but at the same time, making every effort to affect the American industries, because they have had some issues about the anti-dumping measures which were taken by the United States. This dispute was played out actually at 2 fora and was sought to be played out at the 3rd fora, not so successful. The first one was the investor-state dispute settlement mechanisms, where 3 cases were brought by 3 different foreign investors, all of course American. The first was the corn products case. The second was the Cargill case, and there was one more case which was brought by another American investor, the Archer Daniels. So there were these 3 disputes brought by 3 foreign investors, basically challenging the same measure before investment tribunals. At the same time, Mexico, which was trying to defend its measure, was trying to bring proceedings before an ad hoc panel constituted under NAFTA through state-to-state dispute resolution proceedings. And what we see here is when we speak about overlapping disputes or parallel proceedings, we have 3 potential fora. The first is ISDS. The second is the WTO, where there's the panel and the appellate body. And the third is under a free trade agreement or a preferential trade agreement, a state-to-state dispute resolution mechanism. If you look at these 3 pillars, so that's where these cross sections happen. And these cross sections arise from the same measure, but claiming different reliefs and claiming breaches of different rules of international law covered by each of these specialized regimes. And this was an interesting example to see how these different fora interacted with one another when the same issue was brought before ISDS tribunals, was brought before panel in the appellate body of the WTO, and which was sought to be brought before a state-to-state NAFTA, but it never happened because the United States never facilitated the constitution of a panel under NAFTA for a state-to-state dispute. In all these proceedings, Mexico kept insisting that this dispute should go to NAFTA, state-to-state proceedings. Neither should investment tribunal proceed, nor should the WTO proceed. The reason why it was trying to do so, because it thought it had better chances there. And that also speaks about what would be the different consequences if a dispute is litigated before ISDS, or if it is litigated before WTO, or before state-to-state proceedings in a free trade agreement. Now, more or less, the consequences of a state-to-state proceeding under a free trade agreement would not be very different, or rather can expect to be similar to the outcomes at the WTO. As some of you might know, the appellate body is dysfunctional at the moment because it doesn't have anybody to sit on it. Despite that, the panels are functional, and states are trying to make sure that their disputes are resolved through at least panel decisions. One of the attractive features of this mechanism is actually for states, because states try to insist that they should take a dispute to the WTO rather than facing a claim before ISDS. The first attractive feature is the consistency of the system. Article 3.2 of the dispute settlement understanding makes it very clear that while interpreting any of the WTO texts, the panel of the appellate body cannot expand or reduce the obligations of states, which has led to a consistent body of jurisprudence. In fact, if one looks at the panels in the appellate body decisions, they're almost done with mathematical precision, and you can very much predict as to what is going to come out. While we do have that consistency and predictability within the WTO dispute resolution mechanism, there are factors which are also not conducive for an investor, because often the interpretation would tend to be quite narrow as compared to the interpretation that an investment tribunal would provide. Of course, the standards are going to be quite different. And the second set of cases which were litigated before the WTO and before investment tribunals was, or rather an investment tribunal, was the instance of Australia plain packaging. When Australia introduced its law of plain packaging, it was challenged by almost 4 states before the WTO. It was Indonesia, it was Ukraine, it was Dominican Republic. So 4 states were challenging and of course Cuba because of its cigars. So they challenged the same plain packaging measure before the WTO, while Philip Morris, Hong Kong tried to challenge the same measure before an investment tribunal. As you all might know, it was knocked off on the simple ground of admissibility that the planning was done to avail benefit of investment arbitration. But what we do see is in situation like this, where an investor is unable to meet the threshold of jurisdiction or admissibility, if his or her state or a state over which it has an influence is willing to, then it could try to potentially explore the standards available under the trade regimes. And there again, there's a broad panoply of standards that one can rely upon. In the Australia plain packaging case, all these states who were challenging the Australian measure tried to rely on multiple standards which are provided in the WTO treaties. They said this Australian regulation violates the technical barriers to trade agreement, because under the technical barriers to trade agreement, states can definitely have technical regulations for any products or any services which happen within their jurisdictions, but it's necessary that the imposition is less trade restrictive. Although eventually this point was lost because the panel found that the measure which was taken by Australia wasn't sufficiently trade restrictive. So there's a possibility of a technical barriers to trade challenge, which provides the possibility for a state, if persuaded by the investor, to say that the host state regulation is in contravention of the WTO obligations because it's an onerous technical requirement. Or in the same case, there was an issue of intellectual property rights, which was also sought to have been agitated before an investment tribunal, but it couldn't reach that stage because the tribunal found it didn't have jurisdiction because the claims were inadmissible. Some of these claims were sought to be raised as a part of intellectual property right, because the plain packaging had the effect of effacing the intellectual property rights of the holders of those rights. Although there, the panel did look into these issues, but ultimately found out that these are matters of public policy, and this discrimination is probably a reasonable or a rational one. What is interesting, however, is the way in which MFN and national treatment would be applied. An approach of an investment tribunal tends to be much broader than that of a WTO panel. And there is a consistent jurisprudence which a WTO panel would not want to distract itself from. So for states, they often try to insist that they take an issue before the WTO or get it resolved before the WTO, even before it is resolved by say, ISDS. It's also because of the test of likeness is much narrower. If you look at the jurisprudence of ISDS, it's almost all over the place. At times it is the same sector, at times it is the competitive relationship, at times it is same consumer, but the jurisprudence of the WTO is far more clear. It might be narrowed down, but is nevertheless clear. There are these legal implications of where one would want to go, what would be an appropriate place to get a dispute resolved. But that's also a matter of strategy, apart from the law, to look at which side you're representing and what might be the potential consequences of going from one side to another. One thing which I think I should also mention is about the standing. As we all know, WTO, you'll always have to have states filing claims against each other. But right from the early beginnings, from EC Banana's case onwards, the panel and affirmed by the appellate, or rather the panel took a narrow view, appellate body took a broader view, where they said that even if you are not dealing in that particular commodity, the possibility that your trade might be affected in the future is a good enough ground for you to commence proceedings. So in the EC Bananas case, the United States was challenging some EC regulations about bananas. And what the appellate body ultimately found, that even if US is not a major exporter of bananas, it might ultimately affect its domestic market, so it has a standing. And that was the very reason why you have these multiple states challenging the Australian plain packaging measure before the panel and the appellate body. But it's ultimately trying to persuade some state to take up the claim and fight it on your behalf. But as the appellate body is dysfunctional, we don't know what's going to happen to the panels. They're certainly functioning. But what we might see in the future is state-to-state proceedings. That's where some of these issues might now be sorted out by states. But before I conclude, I want to briefly speak about where does this take our discussion about inconsistent decisions in ISDS or in the WTO. In my view, there are two elements of inconsistent decisions. The first is an element of facts, and the second is an element of law. I think the element of law is fairly straightforward. It is a different treaty. It would be interpreted inevitably differently because the text, context, object, purpose, everything is going to be distinct. Not just for the WTO vis-a-vis WTO treaties vis-a-vis ISDS bilateral investment treaty, even between two bilateral investment treaties, their text, context, object, purpose, everything might be different. So we can't really insist on consistency of law. But what we can insist on is the consistency of the jurisprudence constant, which can be seen in the WTO dispute resolution mechanisms, but we don't see in the ISDS mechanisms. Until the time we have the system as we have, whether it's good or bad, I don't think we could really expect any predictability or consistency there. But the question is really of what happens if there are contrary factual findings arrived at. And that's a real problem area. That's something which is going to raise challenges about the whole credibility of the system, not just for the ISDS, but even at the stage of WTO. The possibility of getting more credible facts is much higher at WTO proceedings because there tends to be expert witnesses which are taken very seriously. It is a thorough, as I said, mechanical process, step by step, very well laid out, as opposed to ISDS, and which is also probably the consequence of an ad hoc mechanism, where there's no institutional pressure, so to say, unlike the WTO, which has an institutional pressure to be consistent about what it does. So that's where we stand, where there are multiple avenues. Can we force a unified avenue? As in the keynote speech we heard today, we may be aspirational, but it's ultimately about consent. The party will go on as long as the states want, and it would depend on how that consent is identified and how that consent is specified. There may be efforts to narrow down such possibilities of multiple claims through arguments of res judicata, which we've already heard from Alex, hasn't been very effective. The prospects of it being effective in the future is bleak. So is the case with estoppel. So is the case with lease pendants, and even other theoretical constructs like committee or whatever we would like to call them. So instead of insisting on creating an artificial theoretical framework, insisting on unification of the entire system, I think we have to live with the fact that these are distinct systems. They function on their own principles. Or probably we can say that there are good prospects for trade and investment lawyers to have more work, which is, I think, a good note to end on. Thank you.
Thank you very much to our panelists. We'd like to open the floor up for questions now. If you could briefly introduce yourself at the beginning of your question and try and limit your remarks to 1 minute so that we can get around the room as much as possible. Thank you very much.
Hello, thank you very much. I really enjoy the presentation. I'm Laura, I come from Argentina, and I have a question for Professor Happel. I really enjoy this presentation, but I have a question, whether you think that we're going to have further proceedings in light of counterclaims. And I mean, I'm thinking about the cases against Ecuador, Perenco, and also Burlington, do you think that the acceptance of counterclaim may bring further parallel proceedings and how this is going to affect this issue? Thank you very much.
Sebastian Lukic, and my question also to Professor Happold. Regarding the last point, whether the human rights route can be an alternative, isn't the real problem the approach to damages, to reparation? Because whether a decision by the Court of Human Rights in Strasbourg really wipes out all consequences an investor or individual sustains, I'd question that.
Hello, hi, I'm Lakshna from India. I have a question for Mr. Sullivan. So you were talking about how multi-party claims could be potentially more efficient. I was just wondering if we are recognizing the inherent logistical and procedural challenges in multi-party claims. In all the cases you mentioned, of course, there were unique challenges, but questions of this like sampling approach they adopted in one case, and the question of only common issues being open for discovery in another case, and whether, in your opinion, these would amount to questioning the due process of these proceedings themselves. And if yes, is the balance really tilting in favor of efficiency over due process? Thank you.
Good afternoon. Thank you to all the panelists. My name is Ashna. I'm from Allen & Overy. My question is also to Professor Happold. It's on the conflict between international human rights as international investment tribunals. You mentioned there is a conflict between them. I wanted to understand how would that conflict arise, even if the Human Rights Tribunal were to decide that there hasn't been a breach of the right to fair trial or the right to property. Would that affect the decision of an investment arbitral tribunal? And would that make any difference in the enforcement of an arbitral award?
Thank you. Jeff, I think maybe if we come to you first for that one question for you, and then we can go to Matthew because he's probably got quite a lot to cover. I'll give you a few minutes.
It's a very good question. So you're asking about the balancing up concerns about due process and efficiency. I think the first point I would make is that it's not clear that these, it's not obvious that these claims will necessarily be more efficient, depends on how you define efficiency. The PV investors claim, which I'll, full disclosure, I was counsel for the claimants, took nearly 10 years to resolve. And part of the reason was the mass claim aspect of that. Not the only reason, but certainly part of the reason. But this is the sort of crux of the due process analysis. So you have a mass claim, you must put in place as a tribunal appropriate mechanisms to address due process, but at the same time, not turn this into something that lasts 10, 15 years, right? Otherwise it defeats the purpose entirely. Tribunals, in my experience, and I think most of our experiences, are very due process aware. They don't want to take any steps that might result in an award being overturned. So the question really for me, I think, is what tools can they use to do that? And I think your question is, when does it cross the line between creating efficiencies but then violating due process? And that's going to be determined on a sort of issue by issue basis. So is sampling appropriate? Or delegating aspects to an expert, is that appropriate? It's the circumstances. In some cases, you might have party agreement on these things, in which case it sort of falls away. But if you don't, then the tribunal is going to have to be bold and make decisions. And over time, we'll probably see where the fault lines are drawn as cases get annulled or appealed if they're a non-exit case.
Thank you.
All right. Well, first of all, for those who haven't been following the news, appears there's going to be a new Chancellor of the Exchequer.
Surprise.
Yeah. Was that the shortest tenure of any Chancellor of the Exchequer? I don't know, but it certainly cheered me up when I heard it.
We might have a new Prime Minister as well.
All right. Counterclaims. It's an interesting one for a number of reasons. One of which is, what's the applicable law to counterclaim in these cases anyway? So what, what's the tribunal restricted to? What law is the tribunal restricted to applying to? And also another issue that comes to mind is what's the relationship under human rights law between the obligations of the host state and the obligations of the foreign investor? So I think, if I were a foreign investor, I would be going, well, you can't, you've let us do this, you colluded with us, you can't now claim that we haven't complied with our obligations because you haven't complied with yours. But so there's all sorts of fascinating issues there, which I don't think I can really get into. And I suspect I haven't thought through well enough, but I think it's going to be they are all really interesting and theoretically, but also very practical issues. So I'm not going to say any more about that. Which takes on, I think, to the sort of third point, which was conflicts. I have to admit, I've tended to see this, and I'm now going to engage in some shameless self-promotion. I wrote an article with Johannes Farner a few years ago, which is in the ICLQ, on investment arbitration and human rights. You'll read it, it's very good. Bits he wrote anyway. And there are various cases where it's not so much that decisions of human rights tribunals have been opposed, but there's been very specific alleged conflicts. I'll just mention two ones: Uben and Burundi, which is under the Belgo-Luxembourg and Burundi BIT, where Burundi said, well, we can't. The question was, there were squatters on the claimant's land, essentially. And Burundi said, among many of its defenses, one of them was, we can't evict them because it's contrary to their rights under Article 17 of the International Covenant on Civil and Political Rights, which the tribunal rightly, I think, made fairly short shrift of. So, is there a conflict there? I don't think there is, but there are issues of conflict. And another one which is the Human Rights Court's decision of the Inter-American Court of Human Rights in a case called Sohoya Maxa Indigenous Community and Paraguay. And it's an indigenous community in Paraguay who wanted their ancestral lands back, and the court ordered that they be given their ancestral lands back, despite the fact that title to the land was held by German investors, and there is a Germany-Paraguay BIT. And essentially the court said, we don't care. We think we're applying the American Convention on Human Rights. So there are potential conflicts. What I think, the more specific conflicts, but res judicata doesn't apply in either of those cases. I think it wouldn't even apply. It wouldn't apply if the German investors then brought a claim under the German Paraguay BIT, for the very simple reason that you're entitled to expropriate people's property under conditions. So providing Paraguay expropriated their property, and accorded them due process and gave them full compensation, that would be all right, surely. There's restitution on one side, compensation on the other, everyone should be happy. Well, they won't be, but there shouldn't be a problem. But I think, referring more specifically to cases where there might be a res judicata, you might say it, International Human Rights Court says someone has been accorded a fair trial, and then they nonetheless bring a claim saying that they haven't been accorded a fair trial, and that's contrary to fair and equitable treatment, or something like that. And I think that would be an issue, but there hasn't yet been a case like that, as far as I'm aware. And what's interesting about the final award in UCOS is that, in fact, the tribunal spends quite a lot of time referring to the merits judgment of the European Court of Human Rights in order to bolster and support its conclusions. So I think it is conscious that it didn't want to come up with inconsistent findings as to what had actually happened. So there you are. What more is, human damages? Yeah, damages, plainly. In the European Court of Human Rights judgment in UCOS, they say, well, just satisfaction here is, reparation, full reparation, but obviously they don't give rather nearly as much as did the tribunal. I think you're right. In my experience, and I think this is most people's views, people get, claimants get undercompensated by human rights courts. It's not just in expropriation matters, you see it. They've got better at things like arbitrary killings, but until quite recently, it was much better to be run over by a motorist and claim on the insurance than to be shot by an agent of the state and have to go to the European Court of Human Rights. Many claimants, of course, are out for vindication. They're not about getting compensation for damage for their financial interests. And the court, by and large, I think now, and this is certainly the case of the European Court of Human Rights, I think it's less the case with other human rights adjudicatory mechanisms, sees itself as fulfilling more of a constitutional function than primarily being concerned with doing justice between the parties in each individual case. And that, again, is another reason why one might want to choose arbitration over resort to a human rights mechanism. There are others, but that is definitely one. Have I answered all the questions? I don't know.
Thank you. I think we can probably take another round of questions if there are any from the floor.
Thank you very much. Actually, on the issue of the European Convention on Human Rights, the first case on, I'm trying to see what the online speaker can see me. The first case I ever worked on, the Rusales versus Romania case, we represented Romania, and what the investor did, the Greek investor, he hired apparently a not very expensive local law firm which had some experience with European Court of Human Rights proceedings. And what they did in their submissions is they made a lot of European Court of Human Rights arguments there, like legal certainty, expropriation, things like that. And it was difficult to say, no, it doesn't apply because, that's part of international law. It's a part of obligations of Romania. And so we had to argue, explaining why this doesn't apply and so on. So it can be like a cost-saving technique. If you don't want to hire a top law firm doing ISDS work, hire a local human rights firm and they may do something for you.
You've got a good point there, actually. It's cheap. It's generally cheap to take a case to the European Court of Human Rights. Even what's interesting though is there are now a number of people who specialize in, basically just take cases to the European Court of Human Rights. It's either enormous crooks or corporations. When I say enormous crooks, often enormous crooks have been in politics, I should say. And the former director of Bickel is one of those lawyers who specialize in this work for his government.
All right. Yeah, but that's not really a question. So I have two questions. One is for Aniruddha and another one for Jeff. For Aniruddha, my knowledge of international trade law is rather limited. So I understand that for WTO proceedings, you need to be a state, right? States are involved, not private parties. But when it comes to free trade agreements, which deal just with trade, not with investments, is there any remedy for private actors, or states also have to intervene on behalf of traders, right? Not investors. And my question for Jeff, you would think that finding more claimants could be a strategically useful approach, right? So let's say a state adopted a regulation, changed rules, and not just one investor, but many investors are affected. And so you approach all those investors and see whether anyone would be interested to join this group and assert a mass claim. I remember when I was doing my New York bar exam, after it's not actually was about bar exam, it was about the Barbary course. And they always have this sort of class actions that they monopolize the market, and then you can join this class action and then you will get, I don't know, $90 compensation at some point and so on. But they were very good in tracking all those people who are affected and then settling with Barbary, right? And giving a little bit of money to everyone and earning a lot of money on expenses, right? On fees. And so I'm wondering why this has not yet become a more widespread practice among law firms representing claimants, just to find a bigger group of affected investors and then assert a claim against the state. Thank you.
Thanks, Jack. Thanks, Jarek, for shifting the focus away from Matt and a bit on us as well. So in relation to the free trade agreements, unlike the free trade agreements of the past, which tended to be dealing exclusively with goods, what we are seeing now are a mix of trade and investment. So by trade means trade in goods plus investment, which wasn't the norm before. But that seems to be the new emerging trend. In most of the new treaties which are being negotiated as trade treaties, it's rare to find them not to have an investment chapter. So they do have that investment chapter. Also, what we see is often these free trade agreements or preferential trade agreements are negotiated by governments by a different set of people as compared to the investment treaties, which often tend to be done by the finance ministry, unlike the trade ministry. Of course, it differs everywhere, but that seems to be the predominant reason, because due to the involvement of trade issues, these issues tend to be more technical since the aspects of tariffs, of classification of goods. So inevitably, that tendency to be clear about the rules and clear about their interpretation is far more evident in these texts, and which I think gets crossed over to some of the definitions of investment chapters in those treaties. But they follow the same pattern as the NAFTA pattern, where there could be either an investor filing a case against the state, or it could be state-to-state dispute resolution. Now, there's no reason why an investor may be unhappy with a certain classification of goods and say, I want to challenge that. But for that investor would have to be a manufacturer and exporting goods. Now, that contradicts the very idea of foreign investment, because the investor is sunk in and is settled in the host state, rather than somebody who's in the home state and exporting goods. So the possibility of an investor really trying to seek a trade remedy under such an agreement is rare. Not that it won't happen, but it's really rare. But yes, we do see this new trend, but where with investors having the possibility of resorting to the investment chapter. And often these dispute resolution clauses are narrowed down for the investment chapter for the investors, unlike state-to-state dispute resolution, which is broad and includes trade as well as other remedies. But before I pause or stop, rather, I want to quickly make a comment on what Matthew spoke about the counterclaims. Because if you look at the UNCITRAL discussions, it seems they've kicked the counterclaims ball into the grass, which means we don't know when it is going to come back. In every meeting, they keep saying the first line is, counterclaims are important. We haven't stopped discussing them. We are going to come back to them. And then when you look at the discussions say, well, that's probably a substantive issue. We are only going to focus on procedural issues. So it seems that, they very smartly, as whenever I meet developing countries representatives, tell them that they very smartly confused you, because they're never going to discuss counterclaims, and you're never going to get anywhere, because the only place where you have discussions about or other specific provision of counterclaim is the Exit Convention, which does allow counterclaims under Article 46 and the Rule 46, but it allows counterclaims in a very narrowed down circumstances. And if you look at the entire jurisprudence, there's not a single case where it has been upheld. But if you look at some of the provisions in the ECOWAS, for example, in the African treaties, you find a much broader formulation, or in the new Indian model BIT, which I think has also been followed by some others, where they say that, well, you can just file a counterclaim if it arises out of the same claim, not necessarily the same claim, but in relation to the treaty. There are issues of substantive law, whether how can you bring in issues of human rights violations, whether it's covered by 31(3)(c). That's a much larger area. But yes, there is a possibility of saying that an investor has failed to comply with domestic law and human rights, labor standards, and a state can very well try to pursue that. In fact, there's an unreported case of Indonesia where it successfully did it against a foreign investor, but never succeeded to get the award enforced anywhere in the world because they couldn't trace the assets. So we do have that possibility, but as I said, it's a much complex area, probably which deserves a full panel to be
monograph
to be led by Matthew.
Maybe
Thank
the
you.
next.
So, Yarek, your question about why do we see more of the, class action, U.S. class action style grouping of claims in ISDS? I think there's a lot of hurdles to it. First of all, you need to have a measure that affects a large group of foreign investors. Those investors then need to be relatively similar in terms of the timing of their investment, the nature of the investment, that sort of thing, the homogeneity requirement. And then, of course, you also have to find investors who are willing to give up control to a degree. So if you opt into the Barbary class action, you have no say at all in the legal strategy, right? There's a law firm running that, and you're going to get notice every now and then. And it's not quite as extreme in the context of a mass claim, but there is a degree of claimants saying we have to cede control of our case to the group. So I think there's a lot of hurdles to get over. It's not very often states take measures that affect a large group of foreign investors that meet both, have similar treaty rights and similar investments, etc. And then, of course, I think it'll happen more, but you're never going to see something similar to what you see in the domestic context just because of those hurdles.
Thank you. Are there any final questions from the floor?
As Piers Bunting of Gibson Dunn. You finished up your presentation about raised judicata.
Oh, sure. Sorry. Hi, I'm Piers Bunting from Gibson Dunn. My question is for Anuruddha, and it is about raised judicata in the context of what you were talking about, disputes before ISDS or trade disputes. And I'm not sure this has arisen before, but the question would be sort of how would it arise in that context? And how particularly would you get over the question of privity? Because you can see sort of objectively thinking about it, there is an attractiveness to the idea that you shouldn't be able to have a state which is arguing essentially the same thing as an investor run the same argument in a different dispute, or the investor then run it again, having lost that point. But how would you see whoever it is arguing it get over the difficulty of privity in that context?
Thank you very much. Very interesting question. In my early career in life, I was a domestic law practitioner. So I was trained to look at things in a very meticulous way. But then I realized after becoming an international lawyer, it's pretty fluid and you can bring things in and just throw them in. That's fine. So we see all these arguments being raised without much care about what really they imply. So not just the res judicata, there's the lease pendens also, which is being raised, or rest of it. I think what is worth looking at is how res judicata and lis pendens actually operates, because now there's some effort by, I think McLachlan gave his specialized course at the Hague Academy on lis pendens, and trying to have a bit more flexibility through lis pendens, because it's really on the subject matter rather than the parties. Although the triple test, which Alex so elaborately spoke about, will always be there. And that's where I think, even if you're speaking in the trade disputes, the same parties, that's the first obstacle, is it's state to state, investor state. But as I said, there's fluidity in international law. I wouldn't be shocked if there's some interesting, some might say crazy tribunal which says, well, it's the same subject matter. Or the same cause of action, because cause of action is one of the three elements. And now the cause of action is going to be the same, that is the measure. Or if you look at some of the recent awards, I think it was Wasteland or something, it just came out last year, where whether they were discussing whether there's a decision as such to be treated as res judicata, whether it's a final decision or it's just a provisional decision and we can revisit it. So we do have those complications as well. But if we do end up at a situation where at least, or maybe through a treaty if it is defined, that if it is the same subject matter, then possibly the other requirements would fall away. But in the trade and the investment context, the prospect of running successfully that there is a res judicata and this issue has been already decided is next to impossible.
Okay, just to add a comment on that. Sorry, Alex Slade. I completely agree, and I was thinking that I struggle to envisage a situation where the trade dispute between states would be of the same nature as the investment dispute between the investor and one of those states. But you can see a situation where there might be factual findings, which is exactly what you referred to in your presentation. Now, I think it would be a stretch for a tribunal to decide that there was a formal res judicata issue. But you can, I think, foresee a situation where they might say, well, if that dispute at the trade level is still ongoing, I want to see where that comes out on certain issues, maybe, and you end up with a stay of the investment claim. Or you can see a situation where they pay a significant amount of deference to any decision in the trade context for the purposes of their factual findings in the investment arbitration.
On the stay aspect, if I may quickly, in all the Mexico sweet syrup cases, that's what Mexico was saying to investment tribunals: don't proceed, because it thought it had much better chances before the WTO, and then asking the WTO to stop because it thought it had better prospects before NAFTA state to state. But none of them really agreed with that. So stay and committee have been sought to be raised by some states, but I don't think really tribunals have taken that up. But yes, the point that you raised about a factual determination and its impact. And what we do see, a kind of a subconscious or a soft influence, because in all these sweet syrup cases, all the the NAFTA tribunals, so investor state ISDS tribunals, they all were somehow aware. Of course, the decision of the panel in the appellate body was already out, so they were aware of the decision. But they were always saying, well, we're going to do our own investigation, but we do see there's a fair bit of conversions on where they arrive at. Somebody might say it's just accidental, but it seems to be more deliberate than accidental. Thank you.
Thank you. Well, I'm afraid that's all we've got time for, and I'm sure you're all hungry for lunch. So if you'd like to join me in thanking our panelists, thank you very much.